Preliminary Section 1 and 2. A proposal, when accepted, became a promise under Section 2b. Consideration for the contract signifying the bringing element in the contract. Who among the following has no right to enforce a contract? A stranger to contract. Surrender dog is lost. He advised in the newspaper, anyone who find a dog will get a reward of 20,000. This advertisement is a proposal. An auction turned into binding contract when, upon the falling of the hammer. According to Section 2G of the Indian Contract Act, an agreement not enforceable by law is said to be void. Find out the correct response. Past consideration is no consideration. This statement is correct under English law of contract. The leading case of Carbolic versus Carlyle versus Carbolic Small Box Company is related to general offer. The doctrine of privity of contract means that only party to the contract can sue and can be sued in the contract. Quid pro quo means something in return. Who is called the promisee according to the contract? A person accepting the proposal. The accessory consideration is mutual exchange of promise, one being consideration for other. A notice in the newspaper inviting a tender is an invitation to the proposal. In a contract, consideration could be supplied by even the stranger to the contract. Even promisee and every set of promise forming consideration for each other is an agreement. Which one of the following is correct against contract? Maybe oral. The two main competing definitions of contract in common law are: contract is a set of promises. Contract is a promise or set of promise which the law will enforce. A contract is an agreement giving rise to the obligation which is enforceable by law and recognized by law. One of the basic principles of the common law of contract is that the party to the contract are free to determine themselves what primary obligation they accept. Which one of the following constitute an offer? An advertisement announcing a reward of 5,000 to any person who would find missing dog of the advertiser. Which one of the following is explicitly stated in Section 2b of Indian Contract Act 1882? A proposal, when accepted, it became a promise. In a case of general offer for a valid contract, the acceptor must have knowledge of the offer before the acceptance of the performance. Indian Contract Act 1872 defined contract in the section 2H. Consideration means must have some value in the eye of law, must be real, must not be illusory. Past consideration is valid in India only. An agreement enforceable by law at the instant of one or more of the parties and not the others and other. Section 2I of Indian Contract Act is called a voidable contract. Which judicial pronouncement of Queen Bench of England dealt with the concept of general offer. Carlyle versus Carbolic Small Ball Company. What is the terminology used to describe the situation when two parties make identical offer to each other in ignorance of others' offer? Cross offer. Which one of the following is an exception to the rule of doctrine of the contract that stranger of the contract cannot sue? Family settlement. Consideration for the contract signifies the bargaining element of the contract. Doctrine of privity of contract means consideration may move from the promisee to the other person. A proposal when accepted, it became a promise. Which one of the following is correct? Consideration can be kept, present or future. A proposal as to define the Section 2A of Indian Contract Act 1872, willingness to do or abstain from doing an act in order to obtain asset another day too. Which one of the following statement is correct? A voidable contract is an agreement which is enforceable by law at the option one or more of the party thereto, but not at the option of the other. Which one of the following is an offer? A bid at the auction of sale. Interpretation clause of Indian Contract Act 1872 has been provided in Section 2. General offer open would be open for the world at large can be accepted by complying with the condition of the offer. Which one of the following is not essential for the consideration? Adequate. Privity of contract is that party to the contract can sue each other. Which one of the following ingredient is not essential for the contract? Property. Preamble of Indian Contract Act 1872 stated, whereas it is expedient to define amend certain part of law relating to contract. Section 2D of Indian Contract Act says that when at the desire of promisor and promisee or any other person has done or abstains from doing or does or abstains from doing or promises to do or abstains from doing something, such act of the assistance is called the consideration for the promisee. Past consideration means a price paid or service rendered the desire of promisor followed by subsequent promise. Exception to the doctrine of privity of contract, it does not include equitable mortgage. The display of the article in the showroom with the price amount to invitation to offer. Which one of the fall under the Indian Contract Act, the proposal when accepted it became a promise under Section 2B. Every promise and every set of promise forming the consideration for each other is called an agreement. Every promise and every set of promise forming consideration to each other is an agreement. Which one of the following section of Indian Contract Act 1872 defined consideration? 2D. A proposal when accepted it became a promise. Under the Union of India versus Madala Tithaya is illustrated where the trader was in the form of standing offer. According to Section 2H of Indian Contract Act, contract is an agreement enforceable by law. Which of the statement as to the consideration is not correct? A stranger to it cannot sue. A proposal, when accepted, became a promise. Consideration may be in past, present, or future. Every promise and every set of promise forming consideration for each other is an agreement. The proposal, when accepted, it became promissory under section 2b, which one of the famous cases related to general offer, Carlyle versus Carbolic Spool Company. The following rule is consideration is true. Most move at the desire of the promisor. The Indian Contract Act was enacted in the year 1872. A call up B and asks, "Will you sell me your house? SMS the lowest cash price." B reply, "SMS was the lowest cash price for my house is rupees 1 crore. A immediately sent another SMS by stating, "I agree to buy your house for rupee 1 crore as asked by you." B did not respond. Subsequently, solo house and B's SMS was an invitation to receive offer. The difference between an offer and invitation to receive offer is that an offer is definite without ambiguity. An invitation to receive offer is mere statement with the scope of further negotiation. An offer, when accepted, became a contract, whereas an invitation to receive an offer lead to the making of contract. The juristic concept of contract consists of an offer and accepted. Consider the following statement. According to the Justice Patterson, consideration may be some benefit to the plaintiff and some determined to the defendant. A shopkeeper catalog of price is not an offer. A auctioneer announcement that specified good will be sold by auction and certain day, it is not an offer to hold the auction. A promises to provide maintenance allowances to her maternal uncle in consideration for certain property gifted to her by her mother. A refuses to pay maintenance amount. Maternal uncle instituted a suit. A to enforce the promise. Which one of the is correct statement of the maternal uncle will succeed? Because according to the Indian Contract Act, consideration may be given by the promisee to the another person. What can be catalog of book? Listening price for each book and specifying the place where listed books are available term as an invitation to offer. A, without any request of anybody, extinguish the fire of the B ground. A suffer injury thereby. A promises to compensate A with the whole amount of has been spent in the treatment. Then the contract is enforceable. A tendered newspaper is an invitation to offer. An offer is a willingness to do or abstain from doing something with a view of abstaining assent to the addressee. In the formation of contract, which is not among the essential damages, the accepting given by A on B's invitation for lunch over a phone is not a contract because which one of the following? There is no intention to create legal obligation. Which one of the following statement is correct? A voidable contract is an agreement which is enforceable by law at the option of one or more party thereto, but not at the option of others. An agreement not enforceable by law is said to be void contract. Choose the correct statement. An agreement not enforceable by law is said to be void. Chapter 1 of the Communication, Acceptance and Revocation of Proposal, Section 3 to 9. An offer was sent by the post. The acceptor wrote, accepted on the letter, put in his drawer and forgot about it. The transaction is no agreement as acceptance was never communicated to the proposer. L is sent to the search of G nephew. In the meantime, G advertisement offer 2 to 501. Anyone who find the nephew, A trace the boy. Subsequent knowing about the reward claim to the reward is it is not entitled to offer not communicated to him.